everyone. Today I'm going to talk on the topic various modes of discharge of contract. As you all are already aware about the definition of contract, as per Section 2H of Indian Contract Act 1872, contract is an agreement enforceable by law. When two parties enter into agreement, they must have an intention to enter into legal relationship. Now, coming to the meaning of discharge of contract means termination of contractual relationship between the parties. A contract is said to be discharged when it ceases to operate. That is, the rights and obligations created under a contract will come to an end. Now let us see the various modes of discharge of contract. There are 6 modes, that is, discharge of contract by performance, discharge of contract by lapse of time, discharge of contract by operation of law, discharge of contract by mutual agreement or consent, discharge of contract by impossibility of performance, and discharge of contract by breach. Now let us see the first one, discharge of contract by performance. It means fulfilling or doing the promises about the contract in specified time and according to the terms and conditions. Under this, there are 2 types, that is actual performance and attempted performance. Actual performance means when both the parties actually fulfill their respective obligations within the specified time and according to the terms and conditions. Let's take an example to understand this. Suppose A and B enter into contract for the sale of car, and suppose on the due date A actually delivers the car, and when B actually pays the price, it means both have actually performed their respective obligations. Now coming to the second one, that is attempted performance. Sometimes the promiser makes an offer to perform his promise, but the promisee does not accept his performance nor gives him opportunity to perform. That is, one party is putting complete efforts or one party is making a complete attempt to perform the contract, but the other party is not giving him opportunity. In such case, the promiser is not responsible for non-performance of contract and will not lose his right also. Let's take an example to understand this. Suppose if A gives a loan of 5 lakhs to B, and suppose the due date is 31st December 2024. Now both the parties agree that after the due date, for 1 day of delay, 1% interest will be charged. Now let's take this situation where B is making all the attempts to repay the loan. On the due date, B is ready to repay the loan. B is trying to contact A. B is calling A or going to his home, but A is not available or not answering his call. And suppose tomorrow if A files a false case on B saying that B is not repaying the loan, then in such case what can B do is, B can directly go to court, he can present in the court with evidences that he has made all attempts to contact A, and he can deposit the amount in the court and he need not pay the interest also. In such case, attempted performance will be equal to actual performance. Now let us see the second mode of discharge of contract, that is discharge of contract by lapse of time. That is, both the parties must perform their obligations within the specified time or in reasonable time. Suppose if the parties do not perform their obligations in the specified time, then if no action is taken by the promisee, then he will lose the right to file a case. Now let's take an example for this. The best example for this is time-barred debt. According to Indian Limitation Act 1963, suppose if creditor A, he gives a loan of 10 lakhs to B, and suppose if the due date is 31st December 2024. Now suppose if B is not repaying the loan on the due date, then what should A do? A should immediately file a case. Now the question comes, how much time A will have to file a case on B? Now from the due date, A will have 3 years time to file a case on the debtor. Now suppose if we take the due date as 1st January 2025, then from 1st January 2025, 3 years time he will have. That is up to 2028, A will have a right to file a case on B and recover the amount. Suppose after 2028, if A files a case, then he will not be able to recover the amount. Why? Because by that time, the loan has become time barred. Now let us see the third mode of discharge of contract, that is discharge of contract by operation of law. Under this, we have by death, that is, if a promiser dies or becomes physically incapable of performing the contract, then the contract will come to an end. That is, let's take an example. Suppose we know that Michael Jackson, he expired in the year 2009 in the month of June. Actually, he had to give a performance, he has to give a concert in the month of August 2009. He has signed the agreement with the organizers also, but unfortunately, because of his death, the contract has come to an end. So this is the best example for this. Now let's see the second one, that is by insolvency. That is, if a person becomes insolvent, then he is discharged from all his obligations. Then the third one, what we have is by unauthorized alteration in the terms of the contract. That is, if one party makes changes in the terms of the contract without the consent or knowledge of the other party, then the other party can cancel the contract. Then the fourth one, what we have is by merger. That is, conversion of inferior right into superior right. Now let's take an example to understand this. Suppose you think I own a shop and I'll be having the rights only as a tenant. Now tomorrow if I purchase that shop, I'll become the owner. It means earlier my rights were that of only as a tenant. Now I'll have the rights as that of an owner. Now let's come to the next mode of discharge of contract, that is discharge of contract by mutual agreement or consent. And the first one what we have is novation. Novation means substitution of new parties in the place of old parties, or substitution of new contract in the place of old contract. Now let's take an example to understand this. Suppose if A gives a loan of 10 lakhs to B. Now, before the due date, just B request A saying that instead of me, can you accept that C will repay the loan on my behalf? And suppose if A willingly agrees, then in such case, in this example, the old parties were A and B and the new parties are A and C. The old contract was between A and B and the new contract is between A and C. This is known as novation. Next one what we have is alteration. Alteration means changes made in one or more of the terms of the contract with the mutual consent of both the parties. Now, an example for this. Suppose if A and B enter into contract for the sale of maybe like 100 bags of rice. Now, before A could give the delivery, suppose let us assume that because of floods, the rice crop was completely destroyed. Now, A makes an offer to B saying that if you accept it, then instead of rice, I'll give you delivery of wheat. Suppose if B agrees, then the old contract was for sale of rice, the new contract is for sale of wheat. Now the difference between novation and alteration is, in alteration, the parties will remain the same, only the terms of the contract will change. Now coming to the third one, that is remission. Remission means accepting lesser amount than actual amount due. Now let's take an example for this. Suppose if A gives a loan of 5 lakhs to B. Now B, just before the due date, request A saying that instead of 5 lakhs, will you allow me to repay only 4 lakhs? Suppose if A agrees, then it means what? A is excusing that 1 lakh of rupees. So it means actually A has a right to receive 5 lakhs, but he is receiving only 4 lakhs. This concept is known as remission. Now the same concept of remission in India, what we call, is known as accord in England. And the actual amount received, the actual payment received of 4 lakhs is known as satisfaction. Now let's say the next one, what we have is rescission. Rescission means cancellation of contract by one or by all of the parties. It can be done in any of the following 3 ways. That the first one is by mutual agreement. That is, both the parties can enter into a simple agreement and decide to cancel the contract. And the second one is by an injured party. That is, if one party breaks a contract, then the aggrieved party can cancel the contract. And the third one is by a party whose consent is not free. That is, in case of voidable contract, that is when a contract is, or when the consent is influenced by coercion, undue influence, fraud, misrepresentation, mistake, then the party whose consent is not free can cancel the contract. Next one, what we have is waiver. Waiver means abandonment of right. That is, where one party abandons his right, whereby the other party is released from his obligation. Now, if we take the earlier example where A gave a loan of 5 lakhs to B, and suppose if A excuses B from repaying the complete loan amount, maybe let us take in this way where A and B are best friends. So, looking at the financial problem of B, A excuses A from B. A excuses B from repaying the complete loan amount. That is, A is giving up his right. The last one what we have is merger, as I already said, that is conversion of inferior right into superior right. The next mode of discharge of contract is discharge of contract by impossibility of performance. And in this we have 2 types, that is impossibility existing at the time of entering into contract, and this the impossibility can be known to parties or unknown to parties. Now let's take an example. Suppose if A tells to B, saying that if you give me 10 lakhs, I'll put life into a dead body. Now this is something physically impossible and legally impossible. The impossibility unknown to parties, the best example for this is bilateral mistake as to existence of the subject matter. Now the next one under this is supervening impossibility. It means impossibility arising subsequent to the formation of the contract. Now sometimes it is possible to perform the contract at the time it is entered into, but later the contract becomes impossible to perform because of the certain circumstances which are beyond the control of the parties. Now let us see the situations which will come under supervening impossibility. The first one under that is destruction of subject matter. That is, when the subject matter of the contract is destroyed after the formation of the contract, but without any fault of the parties, the contract will come to an end by supervening impossibility. Now let's take a case to understand this, that is Taylor versus Cadwell. In this case, Mr. Cadwell, he wanted to take an auditorium on rent and he signed the agreement also for organizing a series of musical concerts. But before the program could start, the auditorium was destroyed by fire accident. It means what? Here the subject matter is auditorium. It means when the agreement was signed, the auditorium was very much existing. But before the show could start, the auditorium was destroyed. So this is a case for supervening impossibility. The next reason is non-existence or non-occurrence of particular state of things. Sometimes the parties enter into contract assuming that the circumstances will remain the same, but the circumstances which form the basis of the contract change or do not exist. The contract will come to an end. Third reason is outbreak of war. That is, contract entered into with alien enemy during the war is totally impossible to perform and illegal, but contracts entered into before the outbreak of war will be suspended. Now let's take an example. Suppose if A of India enters into contract with B of Pakistan for sale of mobile phones. So as on today, the situation between India and Pakistan is very much fine. It's very much possible to perform the contract. Now tomorrow, if India declares war on Pakistan because of terrorist attacks, in such case Pakistan will become alien enemy, and whatever contract A of India and B of Pakistan entered, now it will become impossible to perform. This is the best example for supervening impossibility. Now the next reason is change of law. The change of law can be because of emergency or special orders passed by government of any country. And the next reason is death or physical incapacity. If a contract is based on physical skill or talent, and the contract will come to an end if the person dies or becomes physically incapable of performing the contract. Now let's take a case for this. Case name is Robinson versus Davison. In this case, Davison, she agreed to give a dance performance in the musical show organized by Mr. Robinson. But Miss Davison, she could not perform because of illness. Now this is a case where when she signed the agreement, it was very much possible to perform, but because of ill health, she is not able to perform. So this is the case for supervening impossibility. Now the last mode of discharge of contract is discharge of contract by breach. It means breach of contract means failure of a party to perform its obligation. In simple words, breach of contract means breaking of promise or breaking of contract. Now breach of contract is of two types, that is actual breach and anticipatory breach. Actual breach means when a party fails to perform its promise or obligation on the due date. And actual breach can be either express or implied. Express means by words spoken or written. Implied means by actions or by conduct. Now, if you take an example, suppose if A promises to sell his car to B, let's take a due date as 10th of April. Now, on 10th April, suppose if A informs to B by words saying that he's not going to sell the car, then it is express actual breach. Suppose on 10th April, if simply A sells the car to somebody else, then it is implied actual breach. The other one, the second type of breach is we have anticipatory breach of contract. It means when one party declares its intention of not performing its promise before the due date, then it is anticipatory breach of contract. Now let's take an example. If you take the same example, like A agrees to sell his car to B on the due date is 10th of March. Suppose before the due date, let's take it 7th of April. Suppose on 7th of April, if A informs to B saying that I'm not going to deliver the car by words, then it will become express anticipatory breach. Now, on 8th April, that is before the due date, or 7th April, if A just simply sells the car to somebody else, then it is implied anticipatory breach. Now the question comes, what are the remedies available to the injured party if the other party breaks a contract? Now the remedies available to the injured party are as follows. The first one is rescission. It means cancellation of contract. Then the next remedy available to the injured party is damages. That is, the injured party can file a case and claim for monetary compensation from the party who has broken the contract. The next remedy what you have is restitution. Restitution means returning back the benefit when the contract has become void. The next remedy what you have is specific performance. Sometimes the injured party can insist for specific performance of the contract. Then the last remedy what you have is quantum merit. Quantum merit means as much as earned. It means for the work done, remuneration should be paid. Now, if you take a case for this, we have this case Craven Ellis versus Canon Limited. In this case, Craven Ellis, he was appointed as MD of the company, but the directors who appointed him were not having the required qualification. But he worked for 3 months. So, for the work he has done, remuneration should be paid. Now, if you take one more case for the breach of contract, the case is Scott versus Umbergate Railway Company. In this case, Scott, he was, a carpenter, he was a furniture maker, and the contract was entered into between Scott and the manager of the railway company with the supply of 3,000 chairs. Now, Scott has supplied 1787 chairs, and later the manager of railway company informs Scott saying that we don't want the remaining delivery of chairs. So in this case, Scott went to court, and court has said that the railway company cannot break the contracts. So today we have dealt with meaning of discharge of contract, then the various modes of discharge of contract, and remedies for breach of contract. Thank you.